to the House Judiciary Committee this Wednesday morning, April 29th, and we're going to be taking testimony on S-193 this morning. This afternoon, I understand that the floor is going to go long. So the only thing I've scheduled is at 3:30 is 2:08 with Legislative Counsel and Sean Burke. And we should have the version we're going to look at posted today. And I don't recall if I sent it to everybody, but it's posted. But 193, just so the version that I sent out yesterday and to witnesses says draft number 2.1 dated 4/28/2026 at 4:30. The draft we have in front of us, which is the correct version number, is 3.1. I want folks to understand that we are looking at 3.1, but if people could just mark that on there.
It's the same thing.
It's the same exact thing. It's just
the draft number.
It's that I rushed Eric to get this out to everybody, and we missed that one detail.
I missed it. It should have been. I should have got
you
it.
got the right one. 3.1. Yeah. Yeah.
What's weird about it is that I did update, because I was in the header. Eric Fitzpatrick, Office of Legislative Counsel. What's strange about it is that, like, if I had missed the header entirely, then I'd be like, hey, yeah, I forgot the header. But I was in the header, and I updated the date and the time. I forgot to update the version. So yes, that's the only thing.
Clarify for everybody. That's all. You, Eric, could tell us about the latest and greatest that we have here.
It's greatest. Yes. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel again, here to talk with the committee about draft number 3.1 of the proposed committee amendment to S-193, the forensic facility bill. The changes between versions 2.1 and 3.1 are highlighted in yellow, as is often the case. So I'll walk the committee through those. Feel free to jump in with any questions as I'm going along, because I probably will skip and go just focusing on the changes as opposed to the underlying bill, but stop me if you want.
Corrections made?
Say it again, sorry.
Are these changes corrections made?
No, these are, it says this proposed by this committee in light of the testimony the committee heard earlier in the week and last week. Yep.
And some of them suggested by Jared, some of the language.
Yeah, right.
Right.
And by the
No, it's our fault. We can't blame Jared.
The Center for Crime Victim Services, also some of the language is posed by them also. So I'll point those couple of things out as we go through. But the first one, very first thing you see, which you will see many times throughout the bill, is on page 1, lines 11 and 12. Remember, the way the forensic facility is set up now is it is run exclusively by the Department of Corrections. So it's the Corrections Department that's charged with overseeing it, with implementing the rules, with deciding on the management procedures, that kind of thing. So the proposal here is to modify that so that it's the Agency of Human Services that's going to be the entity that's responsible for the forensic facility. And obviously, as we know, the Department of Corrections is within the Agency of Human Services, so it's still going to be the same entity that has oversight of DOC. It's just that Human Services would have the upper level management role. So that you see that page 1, you can see that throughout the bill. Another change that you'll see throughout the bill is also on page 1. And that's just a language change. You see it's on line 18. That the bill up until now had previously described the person who's being committed to the forensic facility as suffering from a qualifying condition. And we looked at the language that's in existing law describing a person in need of treatment, and that refers to a person who has a mental illness, and as a result of that mental illness, et cetera, et cetera. That's the definition of person in need of treatment. So to make those two things consistent, rather than using the terminology suffers from, this has, and you'll see that change is also made throughout the bill. And as I say, that's consistent with existing law, the definition of person in need of treatment. So those are your first two changes. Over on page 2, you'll see that, so remember that in order for a person to be subject to a placement in the forensic facility on the basis of being found incompetent to stand trial. And those are the 4 sort of qualifying criteria that starts on page 1, go around to the top of page 2. For example, they have to be charged by a life sentence. They have to be either held without bail or suffering from that qualifying condition, if not held without bail, that sort of thing. And the existing provision was they also have to not currently be subject to a hospitalization order that's issued by the court, which means they're basically within the Department of Mental Health supervision and custody. So remember, though, when a person is found either incompetent to stand trial or not guilty by reason of insanity, it could also be that they would be, if it's related to an intellectual disability, then they wouldn't be sent to DMH custody. They would be Dale custody. So it's sort of a parallel provision that's being added here on page 2 is, all right, well, if the person's going to be sent to the facility, they have to be not currently receiving treatment from DMH because of that order of hospitalization, or what's added is page 2, lines 3 to 5. Also, same idea, they're also not subject to this order of commitment to Dale, because that also can sometimes happen for the person who's been found incompetent to stand trial. They might be sent to DMH if it's mental illness, but if it was an intellectual disability, it would be Dale. So again, just making those parallel pieces there. And if that's the case, they wouldn't be subject to being sent to the forensic facility.
Yeah.
So, Eric, we heard in testimony that it could be somebody that has like Alzheimer's, and I'm wondering where we think they would be sent.
Well, the definition of person needing continued custody care and habilitation, which is the trigger for Dale custody, is let's see, with an intellectual disability, which means significantly sub-average intellectual functioning existing concurrently with deficits in adaptive behavior that were manifest before 18 years of age, in addition to having attempted to inflict bodily injury as a result of a serious crime. So not a medical expert, but
Right.
I don't view Alzheimer's as being either that or mental illness, but that's
Right, especially because it is an onset for 18
that too.
or a traumatic brain injury after 8. So we don't know where they would go, or if we need a.
Well, I think that would be, this doesn't change that necessarily. You know, that person could be subject to this, but they might not. By this, I mean forensic facility, assuming they committed one of those life max offenses and was found dangerous.
But they're, yeah, I mean, it's interesting. Okay. It feels like it might be full. But they're not subject. I don't know how many people with Alzheimer's can be. A successful competency restoration.
Right.
Thanks.
Yeah. On that restoration subject, that was a helpful segue. Thank you, Representative Richardson. But that, also on page 2, you'll see that what's being added here, this is lines 11 and 12. Remember, so the way the current structure is set up, the person who is committed to the forensic facility, let's say they meet all those criteria, then they have to be reviewed every 6 months, right? So they're reviewed every 6 months, or if the forensic facility's clinical service director comes to the conclusion that the person likely is competent to stand trial, because that sort of makes sense. If the clinical services director says, wait a second, this person may be competent, then they should review at that point as well, rather than waiting for 6 months. So the proposal to add some language on page 2 is that, because remember, competency restoration is also a key element of what's going on at the forensic facility. That's what they're getting. This restoration services is what's being provided to them while they're there, so that they can, if the competency is restored, go back to the criminal division for the criminal charge resolution. So this allows, in addition to every 6 months, and if the clinical service director thinks they are likely competent, or if the clinical services director thinks that, hey, it's unlikely that this person's competency can be restored. If they've come to that conclusion before the 6 month period is up, then the idea is that, well, they can also then go to the court and say, we should have another reevaluation hearing here, because I've come to the conclusion that this person's competency isn't going to be restored anyway. And remember, if it goes into that bucket, excuse me, you end up in that fork in the road where the court's going to have to decide, well, if they can't be restored, are they dangerous? Are they not dangerous? If they're still dangerous, then they stay there for treatment. But if they're not dangerous and they can't be restored, then they go into that release pathway, and they can be released subject to supervisory conditions. But this allows the clinical services director to initiate another evaluation if they think the person's not going to be restored. All right, so that's that. So then, like, what if, again, further on down on page 2, again, remember the court is having this review every 6 months, or when the clinical service director makes one of these recommendations. And what might the court find at that hearing? They might find that that the person is competent to stand trial. What would the court do in that situation? I think you've heard testimony that the language on line 17 and 18 that struck didn't really make sense, because all those parties are going to be at that hearing anyway. They're going to hear about the court's conclusion and their finding in that respect. So the idea here is that, well, if the court finds the person is competent, then the court orders the person returned to the custodial status that was in place before the person was remanded to the secretary. So in other words, wherever they were at before they were sent to the forensic facility, if the court finds it looks like now they're competent, to put them back in that place, and then the parties can go ahead with the trial.
That they're continuing to be held without bail and.
Sure. Yep.
General topic.
Be it. Whatever it is.
Please.
Yeah, that could happen. Yeah. Over on page 3, it's technical, same change I just mentioned, that the request of the party or the clinical services director. It's the same idea that the court ordering that this reevaluation that happens every 6 months, or upon request from the director, that it include an opinion on restorability. So that's in there. I'm going to, well, I will come back to that. I'll stay in order. All right, turn to page 4. Another conforming change I was mentioning, line 12, changing it suffers from to has the qualifying condition. Just clarification on page 4, also that the continued commitment is ordered by the court, reviewed by the court. That's who's doing the reviewing. Page 5, a couple other examples of the grammatical change from to is has the qualifying condition rather than suffering from. All right, so now we're on bottom page 5. A moment here on this. So this is, remember, I was just saying that decision point that the court has if they decide to that the person is not restorable, and the court has to decide, well, are they dangerous or not? And if they are dangerous, then they stay in the forensic facility for treatment. And remember, in that case, they have a review every 12 months. Person is reviewed to see whether or not they're still dangerous, right? But if the person is not dangerous, then the court orders release, and that's page 5, line 9. You know, if they find that the person can be released, the court shall order the release according to these supervisory conditions, as explicit conditions of supervision. But what the bill didn't have was, well, what if a person gets released? They're still under custody and supervision of AHS in this case, not DOC anymore, but AHS. So what happens? Is that permanent? So there wasn't a method for the court to relook at that every month. So that's what this does. It provides a similar every 12 months, the court looks at it again. Same way if the person was dangerous and was being held at the facility, once a year, the court looks at it. And here, same kind of thing. The court does a review every 12 months. And in that case, they would be released from AHS custody and supervision unless the state's attorney demonstrates by clear and convincing evidence, over on page 6, that continued treatment and supervision is necessary to prevent the person from becoming a substantial risk of bodily injury. So remember, because they aren't right now, the court already found that they're not dangerous. But if the state attorney can show, yeah, well, they may not be dangerous now, but they might become so in the future, well, then they could still keep them under AHS supervision. But if not, then, you know, at that point, they're released from custody. That's the idea. There's been a non-dangerous finding, and then a year later, still not dangerous, basically. I think those are the major substantive changes. Just looking at page 7 now. Again, all these conforming changes, so we're not referring to Commissioner of Corrections anymore. It's the secretary. Oh, actually, there's one more piece I'll get to. Some more technical stuff, page 8. So over on page 9 and 10, this is the language I mentioned that had come from the network, I believe, or Center for Crime Victim Services. I think it all looked at this language. And this is, remember, we're dealing with that sort of related but separate section. It's a section 2. And this is the piece where where they're providing the court with the ability to dismiss charges against a person if there's been a finding of not competent to stand trial, and then the case was inactive for a period of time, right? If there's been a finding of not competent, the case is inactive for a period of time that's basically equal to or greater than the maximum sentence for the offense. And it has to be a misdemeanor, by the way. This can't be a serious felony of any kind. It has to be a misdemeanor. So what this provides is, all right, before a dismissal like that happens, the court has to, and you see starting on line 12, the court has to have a hearing, and state's attorney has to make a reasonable effort to find the victim, to provide the victim with prior notice of the hearing. Court is required to continue the hearing if the victim isn't not provided with the notice. And then at the hearing, and this is subdivision B, page 9, at the hearing, the court has to ask if the victim is present, and if so, whether the victim wants to be heard. So basically, you're talking about some process here for prior to the dismissal of the charges against the person, dismissal of the case against the person who was found incompetent, to have some notice to the victim and allow the victim an opportunity to be heard. So that's the gist of the language you're looking at here. I think that's some more technical stuff on page 11.
There's a question about that section.
Yep.
I'm wondering how it would work. Line 13, it says, the state's attorney shall make a reasonable effort to provide the victim with prior notice. And then also that the court shall continue the hearing if the victim has not been provided with the notice. So what about, how does this address examples where the state's attorney makes a reasonable effort? Yeah. But the victim perhaps cannot provide that notice.
Right. So two things I'll respond to that with. Number one, this language is really the language that was offered by the victims group. So I think that there wasn't time for me to tweak it much yesterday. So I think that's a question that you would want to confirm with them. But having said that, the way I would read it is that reasonable effort is enough. And that's the way I would read it. And I would say, well,
Okay, I see.
Hearing of the victim has not been provided with the note, because there's no period after the word notice, right? Has not been provided with the notice required by this subdivision. And what the subdivision requires is a reasonable effort. So if they make a reasonable effort, then I fire the judge, which I'm not. Then I would read that as saying, then they did what they had to do. They couldn't find the person, they tried.
I see that now. Yep. Thank you. That's helpful.
Yep.
Eric, do you have a question?
I know.
Go ahead, Eric.
Yes, absolutely. So let's see, some more technical stuff, lines 11, 12, again, changing the Commissioner of Corrections to the Secretary of Human Services on several different occasions. Also making that same conforming change, saying that the person has a qualifying condition rather than not suffering from. More instances of that on page 13 and 14. Okay. So yes, this I did want to mention. This is on page 60. This is, yes. Yeah, a couple more provisions here. So you'll see that's because remember, as we were talking about, this restorability is a key part of what's going on at the forensic facility, and it triggers a lot of findings that the court has to make, right? The court has to make a finding about if one of the parties requests that the reevaluation hearing include an opinion on restorability, then the court has to do that. And then whether or not the person's restorable triggers whether or not the person's going to continue to be held, whether they're going to be released, of course, subject to supervisory conditions. It's a big legal decision that the court has to make, as well as a required method of treatment that's going on at the facility the whole time that the person's there. So the proposal is to add a definition of what it means for competency can be restored, because that's obviously the crux of the finding the court has to make. And the language is that it means a substantial probability that in the foreseeable future, the person will attain the capacity to permit the proceedings to go forward. So again, that language was provided by Jared. I asked him where it came from and didn't get a chance to hear back from him yet. So I think you'd want to find out what the source of that is. I'm not certain what it is, off the top of my head. So whether or not that definition works, may be a question that you want to ask witnesses about. But I think the idea of including a definition does make, from a drafting perspective, makes good sense because it's such an important part of what the court has to find.
Is foreseeable future used in any other legislation that you're aware of?
Foreseeability is generally, whether those two words together, I'm not sure.
And in general, what does foreseeability mean? Does it mean something different if you're a 50-year-old than if you're a 10-year-old? You know what I mean? Like,
Yep.
it seems very subjective.
Right. I think that, like, at least in sort of in a general legal sense, it's sort of often looked at as a reasonable person, but a reasonable person in the circumstances of that person. So in this case, I would think that foreseeability would be modifying the fact that it's a professional clinician who's making this determination about whether or not, in a reasonable period in the future, the person might attain the capacity to basically be restored to competency for purposes of the criminal proceeding. So that's where that language came from. Also on page 16, you'll see there's some procedural language about because there's a number of different hearings that have to take place in the context of this forensic facility. And language in subdivision 3, line 15 of page 16 is providing that before you have any one of those hearings, the person who's subject to the commitment order, at the request of the party, has to permit an expert assessment of the person's competency, forensic risk, or restorability. And that makes some sense because those things all have to be decided by the court. So you're just saying that the person has to participate in those types of analysis. All right, there's some more technical changes about the secretary and the commissioner. Then over on page 19, you'll see a new subsection F is being added. And this is, again, procedural related to these hearings that happen frequently in the context of the forensic facility, requiring the secretary or the secretary's designee or an evaluator who submits a report has to testify at the hearings if requested by the court or a party. So if somebody wants to hear from the secretary or the secretary's designee or an evaluator, then they are provided the ability to hear from them at the hearing. Page 20 and 21, you'll see it's highlighted. That actually isn't new. That's just still hanging around from the previous draft. And that's kind of goes to your question, Representative Burdick, about whether any of this language was from the House Corrections and Institutions Committee. This isn't from that committee, but I kept it highlighted because for the most part, that committee is looking at sections 4A, 5, 6, et cetera. And this committee isn't sort of confining its changes to the first three sections, but this is an instance where, based on some requests from the crime victims groups, that this language was added by this committee. So I just have kept it highlighted so that they are aware over there. Hey, just so you know, here's a change that's proposed by Judiciary to the sections that you guys have been looking at. That's why that's highlighted. And on a similar point, sorry.
I don't want to interrupt your flow, so if you want to keep.
Thank you. Yeah, I will just finish up that point. It's a technical point, but for a similar reason, in these sections that are primarily being looked at by the other committee, I didn't make the conforming change because it still refers to Commissioner of Corrections, you'll see many times in these sections. So rather than just going in there and changing that now, that's still sort of in the discussion process. I figured I'd just hold off on it for now, see where it ends up. And then if you end up going with that route, then we can, square up those sections afterward. So thanks. Sorry to interrupt.
No, that's fine, Eric. So one of the question I have, and you kind of prompted this with, and I realize it's not necessarily applicable to the question I'm asking, but the language that you brought up about designee and designating the secretary has that ability,
Right.
Because one of the big concerns that we've heard about this legislation thus far is the placement being in DOC and not in AHS, which now obviously that change has been made.
Right.
And I'm wondering, given the fact that the commissioner effectively reports into the Secretary of Human Services, if the secretary could designate the commissioner as the administrator of the forensic facility if they so choose.
I think that that's an interesting question. They could certainly designate them for purposes of subsection F to sort of provide testimony. That's
Right.
certainly true.
But the actual administration, I'm wondering.
Yeah. I'm kind of reading it as more like that, at least in terms of the final authority, the person with final authority, I would read it as it's still being the secretary. But in consultation with, like page 19, right above the new language, for example, that to consult with corrections and mental health, et cetera, but sort of the last word sort of situation. Now, they might, I would think, it's sort of a managerial authority, be able to provide a lot of that managerial authority as part of their role as secretary to the corrections department. But, the final decision about things might be with the secretary.
Right. And that's kind of what I go to, like, when you study any great leader or executive or politician, right? Like the authority and the ability to delegate effectively is what I would argue is a hallmark of a great leader and a great skill set and attribute. So it seems to me that while the language in the draft legislation might have changed, the principal authority lies with the secretary, but the secretary could easily delegate that authority to their subordinates.
Yeah, I don't think it prohibits that at all.
Thank you. That's really helpful. And I always appreciate your forthright answers.
Right.
And I'm not being facetious. I don't really mean that.
But I can be. Sometimes I do have to kind of waffle a little bit.
No, but I appreciate it. You make best efforts to answer the questions that we ask.
Oh, thanks.
So I just appreciate that.
Any other questions for Eric? That's all, or is there anything else? If there's more,
Let me just.
some yellow on page 20 and 20, but I thought that.
What page? Sorry.
We did that.
Oh yeah, I'm sorry.
The
We
victim.
were-
Yes, that's the stuff I was mentioning is left over from the previous draft.
Right, okay.
Yeah, about the rules addressing the victim notification procedures. I think that's all I've got. Just double checking one thing there. Nope, that's good for now.
Other questions? We'll go to.
No.
Yeah, sorry, Tom. Yeah.
When we were on page 2 or 3,
Yeah.
you being a Yankee fan, you mentioned the fork in the road,
Right?
and I thought you were gonna say to take it.
Yeah. From Yogi Berra. I remember it well. Exactly. You come to a fork in the road, take it. Yeah.
Yeah.
All right, so we'll go to Karen Barber next.
Good morning. All in my chair. For the record, Karen Barber, General Counsel of the Department of Mental Health. I assume that you want me to react to this, or did you have a specific? Okay.
Yes, exactly.
So I will say, unfortunately, because we just got this last night, we haven't had a chance with the changes to really discuss at the agency level and understand kind of the implications of this. So I can't really speak to that piece right now. So I'll just make a couple other comments. I did just want to note that the conversation around excluding the Act 248 to be parallel to an order of hospitalization. I do just want to be clear that it's not really parallel. An order of hospitalization is a secure option, and Act 248 is not. So I think Dale can speak more to that, but did just want to highlight that those are very different things. The other thing I just wanted to comment on was on page 16, starting on line 15, just around requiring a person to participate. I I think I've said it before that we do struggle with individuals refusing to participate in evaluations. That is a real issue we see. So I think the legislature taking some steps to kind of think about that makes a lot of sense, because that is something we see quite often. So those are unfortunately really all the comments I have right now, but happy to answer any questions.
Any questions? Okay, yeah.
I guess, thanks as always for your testimony. I'm just wondering, any initial reaction on the shift from corrections to human services?
I think when we support it being the Commissioner of Corrections, we haven't had an opportunity to kind of understand or think through the implications of trying to shift it. So
Yeah, that's fine. After you do, because we just got it late last night as well.
Yeah.
So when you do have time to digest and come back, I
yes.
love your feedback, because I heard your testimony is very well taken.
Ken?
So what Representative Harley just brought up, regardless, they're all still gonna work hand in hand together, right? I mean, it's not like maybe Department of Corrections is gonna house it because we can't build, like I've said before, an Amazon anywhere in the state, or pretty much anything anywhere. So it has to be kind of in an existing area, location, existing building, I'm gonna say, stuff like that. I'm tiptoeing around things. But it's like, we don't need to make this that complicated. And who's ever over, everybody's gonna have or the different entities are gonna have a different way of handling each piece of this to make this happen, to keep Vermont a safer place, and to help these people that need help, if it is possible, and generally just keep Vermonters safer. I mean, this situation, the people that are there are already in an institution, or however I'm, trying to say it, correct?
Some of them are in the community, which is part of the gap we're trying to fill. But yes, some of them are already in corrections, or are in corrections at some part of the cycle.
I just really, really, really struggle with why this has been so hard to get moving, to get something that's so essential to get done in this state. And I don't have an answer for it. Can you help me?
The administration has come before the legislature for over a decade asking for this. So I don't have an answer for you. I think we've highlighted it as a gap in the system.
Thanks.
Yeah. Just to your point, I think absolutely the reason we felt it was appropriate under the Department of Corrections is because that's where we had envisioned the facility being. I think, of course, everyone is going to be involved, and that was already part of rulemaking, and we do work collaboratively together as an agency. I think the thing we need to think through is custodial commissioners have certain statutory authorities and responsibilities. And so shifting that, we just need to kind of think through the implications of not having kind of the statutory structure that other commissioners have. And so that's why we just need time to kind of think through what that looks like. But in no way do we disagree that it would be an agency approach. It's just kind of the legal implications of
So we keep thinking, but we're not doing it, or we're not doing certainly enough, right? And then we all know whatever you start is we're going to have to make adjustments as they go along. It's not that complicated. It just seems like, to me, like the political atmosphere wants to keep it complicated, so we don't do anything. And I think that's a disgrace. Thanks. Not taking it out on you, by the way.
So, having spent a long time working on this myself and trying to get it through, been working with Karen on this. So last biennium, seemed like we were pretty close. And then the solution that was then put forward as a solution was River Valley. And if you could comment again on how that has not proven to be a solution and why we continue to do this, because that was the concept coming primarily out of the healthcare committee, that this was going to deal with this population. And what I've now heard, because we've come back again, is that it's not the case. So if you could address that.
Absolutely. So, so 2 years ago, we did get close. It started the year before, I think the first year of the biennium, when we had put forward the Vermont Psychiatric Care Hospital, because we thought there was an option to use the way VPCH is set up is there's 2 wings, and each wing has 2 units. There's 2 8-bed units, and then the other unit has a 5-bed and a 4-bed. And so we thought we could use the second wing, those 8 beds, as a potential forensic facility. And so that is what we had put forward. However, what we realized was that that actually was not an option. In order to do that, either all of VPCH lost its accreditation and its funding, or we had to do serious renovations and essentially take away services from one population or another. Because what we found out from CMS was that they couldn't commingle. We had assumed that as long as they weren't in the library at the same time, everyone could use the library. As long as they weren't in the yard at the same time, they could use it. And what was clear to us is that that was absolutely not acceptable. There could be absolutely no overlap. They couldn't use anything of each other's. And so what we realized was VPCH wasn't an option because we need those facilities for the folks that are in there, and it would have taken away from that. So we had to take VPCH off the table, but we still wanted to explore other options. And so even though VPCH wasn't the option, we were still exploring the forensic facility. When it became very clear to us that the policy committees were not going to support a forensic facility, DMH said, okay, there are things we would like in our system that we had been asking for several years. And if a forensic facility is not going to go forward, we'd still like to get the things we would like. And so the idea was never that River Valley would be a forensic facility or that it would be a fix. The idea was that we've already done all this work and you have a bill. Can we add some of our language? What we had been asking for since the creation of River Valley was to do emergency and voluntary procedures, which is seclusion and restraint, and non-emergency and voluntary medications, so court-ordered medications. And we felt like that was an important part of River Valley because some individuals are still struggling with taking medication consistently. And some individuals need episodic emergency and voluntary procedures, meaning, every once in a while something happens and they need to be secluded or restrained. And what happened before we were allowed to do that under our license is that they would have to be moved to the hospital. There was no choice. We couldn't do it. But now we can maintain them at River Valley and continue to work them towards discharge. It doesn't interrupt their whole stay like it used to. So those are tools we asked for in our system. We said that would allow us to take more acute folks, forensic or non-forensic, right? Because you're in River Valley, it doesn't matter where you come from, you're there because you're clinical needs. So I think it did get confusing to folks because I think there was this sense that maybe people thought River Valley was going to be the forensic facility, but that was never the idea. And the idea was simply that it was giving us more tools to handle the populations that we're serving so that we can better serve them.
Yeah, I think maybe the confusion was that criminally justice involved individuals with the high acute needs were being committed to that facility. And that's, I think, where confusion has occurred. That's still not capturing part of the population that we need to capture here.
Correct.
So, Ian.
It's very helpful. Thank you for that context because I'm new to this whole conversation. 2 questions. So the people who are at River Valley right now, are those people on orders of hospitalization?
No, orders of non-hospitalization. So they're a specific type of order of non-hospitalization. The court has to find that there's no less restrictive setting available, but it's a residential level of care. It's not a hospital, and people go out into the community very often. So it's very different from a hospital.
And then 2 other questions. The loss of funding, and that's federal. And then when it was Waterbury, why were we able to have people sort of in a competency question in that facility and not lose our accreditation and funding?
So we have people now in the hospital that are incompetent, right? The idea is that it has to be solely based on their clinical need. And the people we're talking about in this facility don't have a clinical need to be in a hospital. And the people we were talking about putting in that 8-wing at BPCH didn't need to be there for for a hospital level of care. It was the forensic population. Does that make sense?
Yes, and in Waterbury, they weren't holding people who were on orders of non-hospitalization.
Correct.
Yeah, that was like a hospital.
That's a hospital. Yep, that's hospital level care.
Thank you for walking me through that. That's
Yeah,
very
no, it's
helpful.
confusing.
Yeah, I guess one last thing, I guess, as well, is that the focus then, from what I'm recalling, was not on competency restoration either. It was where individuals should be held as they were getting treatment until they could be discharged. And this kind of changes and focuses on the competency restoration component.
So the initial idea was that there would have been a competency restoration component. That very quickly became clear that there was not support for a competency restoration component. So that's where the competency restoration plan report came out of. And so we kind of took that out of the bill, that first biennium, I think, moved forward with the idea of a forensic facility. And then we submitted a report on what potential competency restoration programs could look like.
Yeah, okay. Okay. Any other questions for Karen? All right, so let's see, who are we going to go through next? Well, Matt Valerian was supposed to be coming at 10 o'clock, but not seeing him yet. Jared, were you prepared to go now, or did you want to go later?
I'm happy to go.
Okay, yeah, if you can go ahead, identify yourself for the record and proceed, thanks.
All right, good morning, everyone. My name is Jared Bianchi. I'm a deputy state's attorney for Bennington County, testifying for state's attorneys and sheriffs. And thank you, Mr. Chairman and members of the committee. I'll address first some things that I heard in your walkthrough with Eric and with some other folks. First of all, the language about foreseeability, the definition essentially of restoration to competency, that comes directly from 18 USC 4241, which is the federal competency statute. The benefit of that is that it is longstanding and that we would come to these cases with jurisprudence on interpreting those terms. But that is a phrase that is taken from the federal statute.
Could you give me the citation again?
Yes, it's 18 USC 4241.
Thank you.
Also, with respect to the conversation about the requirement to notify victims and the continuance of a hearing being required, we would suggest that the phrase may should replace the word shall on page 6.
So with that, I was thinking, or in a conversation offline with Charlie Glisserman, the question of may versus shall, obviously a big difference in the implications, but having some sort of out for the court if there are certain circumstances, like that, for instance, state's attorney has used all reasonable means to contact the victim and hasn't been able to, and there's not really additional ability to get a hold of that victim, for instance. So I'm concerned, maybe if it's a shell, there needs to be an escape clause of some sort.
And that could be, but I think that, our suggestion would just be simply may. However, if the committee goes a different route, that's fine.
Sorry, Jared.
Yeah, go ahead.
You're talking about page 9, not page 6, right?
Oh, I apologize. Yeah, the page.
And are we talking about placing the court shall continue,
Correct.
or may continue? Yeah.
So page 9, line 14.
So changing shall to may, you prefer shall, or do you prefer may? I'm sorry.
We prefer may.
Oh, I'm sorry. I thought it was the opposite. Okay, all right.
And that makes a lot more sense to me.
Right, okay, thank you, yes.
Specifically on it looks like line 14, the court may continue.
Right, gotcha.
transition to the secretary from the Commissioner of Corrections. Sort of in a similar boat to Karen, we'd like to consider this a bit, and we really want to, inform our position in collaboration with the agency. So if we could have some time to reflect on that and have those conversations, that would be helpful. But the big change and where I think this draft, which does make some beneficial edits, really loses the plot a bit, is the exclusion for the Act 248 population. And when I testified first in front of this committee, I showed you all a video of a person stating that he was a killer, that he was fine being a killer, and that there was nothing anybody could do about it. That person then went on to kill somebody in broad daylight by slashing their throat in downtown Bennington. And you heard testimony from that victim's mother. That person is a potential Act 248 qualified individual. And nothing about the reality of what would happen if that person goes on to Act 248 addresses the issues that this bill is supposed to address. So it would exclude families like Kelly's family, and it would essentially render all of this victim language that you're including in this draft as a hollow promise, because for important parts of the population, they're not going to be part of this process. Act 248, simply put, is not the same thing as an order of hospitalization. Act 248 is the community component of what once included something like the Brandon Training School. That component of the statute was repealed decades ago. Act 248 is not about a level of care assessment in the same way that an order of hospitalization is. An order of hospitalization has its own distinct civil component, which can be triggered at any time. I had a case yesterday where a defendant in DOC custody was determined to need hospital level of care, and so he was transitioned. And so the initial exclusion for the hospitalization level of care people was to make clear that the people who need that level of care are getting that level of care. It is an entirely different process, only triggered by criminal proceedings that cause Act 248 to come into place. And it is not the same type of analysis that would make a person requiring that higher level of care. Simply put, they would be, and the person that you saw in that video and who killed Kelly's daughter would be effectively, watched at home by designated agency staff. And that's a problem. And the point here should not be to just pass any bill that says forensic.
So just a question to follow up on that, and I appreciate your expanding on what you said the other day, and part of the reason I asked to have this language in here because I thought we did need more discussion on it. So if somebody is a high risk individual going into Act 248 and they talk about the least restrictive environment, can't that be essentially a community, but it could be a locked and a restrictive environment? I guess that's the point I'm trying to understand a little bit better on Act 248. I mean, yes, it might be a lesser restrictive environment than forensic, but the reason I also raise this is that there was an issue last time we looked at this, last biennium, in one of the so-called poster child of the developmental disability individual who was kind of touted as a person that would need this forensic facility, but we didn't get that. And Dale did find a placement that was secure for that individual. So that's kind of what I'm up against as far as with on the Act 248. I'd love you to comment on that a little bit further, to make sure I'm understanding.
I think it's really important to understand that what happens when a person is placed on Act 248 is, first of all, they can only be placed on Act 248 if there is a designated program available to them, and that program is designated by the commissioner. Right now, the designated program is HCBS, or Home and Community-Based Services, which are Medicaid waiver-funded services that have limitations on the degree to which they can be used. I think that even in the existing structure is probably a very expansive application of those waiver services. But yes, in high, what I'll call high flying cases, or especially high level cases, The amount of money to essentially put a person in a heavily staffed house in a very rural area so that the staff can be assaulted, but not other members of the community, is basically what you're looking at. And I'm not permitted to share names with you, but that's, you have, generally speaking, oftentimes Act 248 cases not requiring that level of security. But when they require that level of security, what I see as a prosecutor is I get a lot of calls and assaults and things like that on staff in very secluded placements where they have things like essentially panic rooms for the person. That's not safe. There have been elopements, and that is the gap that we're trying to get to. I could also point out that the way that the bill is drafted right now, that the person who is excluded from this is a person who is already on Act 248 and then commits a life offense, which I don't think is the committee's intention. But because the way that the process is different from an order of hospitalization and can only be triggered with an order of hospitalization can arise at any time, civilly unconnected to the Act 248 process. The Act 248 process, the only way that the person is subject to that order is if they've already been adjudicated through an Act 248 proceeding. So it would not co-occur in the way that an order of hospitalization can. This is going to create a substantial degree of uncertainty and create a substantial, we would say, lack of safety, but also it's going to cause litigation that delays care in the way that we are trying to address now, and that ultimately will deprive the defendants that we are talking about in this bill from eventually being able to access the process that's due to them to have their cases tried. This is an issue we have. Karen had a conversation with you now about the history of different sessions. This is an issue that, it's my understanding has come up in another committee. We would be happy to testify, but have in none of these sessions discussing this issue have we been invited to testify at House Human Services. And so this is going to leave victims in no better a situation, citizens in no better a situation. It will leave people who have intellectual disabilities without the possibility of accessing their due process. It leaves Vermonters unsafe in a substantial way, and not every compromise is for the better. So we don't support that change.
Understood. Okay. So I guess part of the issue is really with the Act 248 process that there's not a designated program that essentially fills this gap that we're talking about. They may have found something for this one individual that I've heard mention of, but that may be very much a one-off. So we're still, there's this, when somebody's not restorable, we have this exit ramp there. If the person's not dangerous, there's still to look at the least restrictive environment. And presumably that could be something less than the forensic facility if in fact there is such a location.
Well, I think the important thing to remember is with the orders that the court can issue for the people who are not going to be in the facility but are going to be subject to an order to be monitored, there's broad authority for the court to issue orders. So it would be envisioned, for instance, that a defense attorney or a prosecutor could say, Judge, I want you to issue an order for a person who experiences mental illness that they take their medication, or for a person who is experiencing intellectual disability that they enroll in and comply with services from Dale. That there is no limitation on the ability of the court in the way that the last draft was to order them to comply with those services in a monitored fashion. They would just be monitored by field staff as well. So that this isn't removing the opportunity for those resources to be applied to them in the community if it's appropriate.
Okay. All right. Thank you. Yeah, Bart.
So I have a couple of questions, but in particular, the follow-up to the question that the chair just asked. Other states have developed safe and effective community secure placements. There are models that are working. And I know you said it takes a lot of money, but so does a forensic facility. And if people have different needs, taking that money and dividing it up to make sure we have that range of services seems really important.
I think that I can't imagine that there is a resource that we would not support seeing applied here. What I would say is that there is nothing in this structure that would prohibit you from doing that, and thereby expanding the options for the community who needs supervision in the community, but doesn't necessarily need to be in that highest level of care. What you're talking about is building out those less restrictive options so that the person can propose a wider range of plans to the court for their release.
And I wanted to ask you about competency can be restored, means a substantial probability in the foreseeable future. So I was trying to look at some of what some of the other states have. And I noticed Ohio uses the same language. However, they have a 1 year maximum. And while only there are 30% of the states, I guess, that don't have a prescribed maximum for the most serious felonies. Many states seem to, and again, I know that we had the conversation about the federal citation and law and the Supreme Court Jackson, Indiana case, but it does seem like it's somewhat controversial still. So it also looked like some states used likelihood within a reasonable period. Again, that doesn't seem as clear either, but I just worry about foreseeable future being so vague.
Well, I think I have a couple of responses. First, I think that this bill, as a complete package, is already substantially, I'll just say, substantially watered down with respect to a lot of provisions that you would see in other states. So, as a total package, this is already something that people would not be able to expect in those jurisdictions. I think the benefit of using federal language as opposed to any particular state is that there is a lot more case law that we can bring to the application of these terms. And unless we determine, that if we are picking from a particular jurisdiction, then we're going to be stuck with all the idiosyncrasies that also flow into those state determinations. And there are, state constitutional issues that do or don't arise under.
Oh, Jared, you just froze.
And it provides for some consistency and predictability of application. But there's already a lot of provisions in this bill that go above and beyond what is absolutely required. And I think allowing the judge who is ultimately tasked with making these determinations to make them is not inappropriate.
My last question is, in looking again at state by state and what they have, while I understand a full forensic evaluation doesn't need to occur maybe more than every 12 months, it's rare to have such a long time period. Like a lot of states, it's like every 45 days, every 90 days, every 30 days. And I'm concerned that somebody who has yet to be found guilty is being held for 6 months unless somebody initiates it, and putting in statute more frequent reviews, especially in just talking to treatment providers, it takes too much of the urgency off of treatment providers too, to be like, oh, well, we have 6 months with this case, so you don't necessarily need to step things up. And I guess I don't see the harm in making it more frequent.
So we are talking about people facing charges of murder, kidnapping, and sexual assault who are being held right now without any treatment services while these issues are being litigated. I think that I can appreciate the perspective that you're bringing to the question, but I think ultimately, from my perspective, the main focus needs to be on not allowing those risks to continue and to allowing those people the process necessary to have those cases either tried or to have them safely supervised. And these time periods are not inappropriate. They are consistent with other jurisdictions, and they provide a process for that review no less often than every 6 months.
So I'd love to see what jurisdictions you're seeing because I'm not seeing that. And frankly, I'm concerned because, again, it looks like if people are restorable, even for the most heinous crimes, it looks like that it's within, it's not in a 10-year period by any means, or even a 5-year period. It's a shorter window. And I've looked at several different research articles on this. So I just worry about that whole time frame that's set up sort of leads to people lingering in a particular resource that may be needed for new people. And it may be that having the secure residential programs that they could be sent to, if they're not going to be restored, may make sense.
I understand what you're saying.
So is it more a matter of reporting to the forensic facility, what's the terminology? The overseer of the forensic facility I mean, having it every 45 days in court seems to be certainly excessive, because that's what this is setting up.
Or even 90 days.
Is setting up court hearings.
So it's right. So it's 6 months, and then after later on for other things, it's like every 3 years.
That's only for not guilty by reason of insanity.
That's on the not guilty.
Right. Yes, but for the other part, it again, the 6 months is sort of an outlier. I'd love to see the jurisdictions that you say use that. If you can give me that info, I'd be very interested.
Okay.
So if you can follow up, Jared and Zach.
Jared, thanks very much for outlining your concerns with the legislation as it's been redrafted. I think you make a really important point about the impacted population of the people that we're looking to deal with here, in the fact that they've been charged with some of the most heinous crimes in statute. And so one of the questions I have, and you brought this up earlier, is the HCBS, the home care based services. I'm just kind of curious if we can delve a little bit deeper in whether that is a reasonable or even effective therapy for the population that we're dealing with here.
So I see this bill as having sort of two components. One is for folks who a judge has determined needs to be in a locked facility. I would say it is manifestly not appropriate for that population.
Right.
I think that for the population who that would be appropriate for, the piece of the legislation that allows the court to issue orders for their supervision in the community would allow them to issue an order saying that they need to enroll and comply with the services.
Thank you. And my next question is, the statement that you made is one that resonated with me particularly strongly. It's the hallowed promise of public safety for the people of Vermont, with the legislation that's drafted. And I think, we've heard extremely compelling testimony from impacted parties on this, namely Kelly, in the horrific loss of her daughter. I'm wondering if you have changes in language that you're going to be recommending, and if you do, to put those protections back into the bill that were hollowed out. But I'm wondering if you would share those with the committee, either now or if you're working on redrafting language, if you can give it to us in the future.
I mean, the quick answer is that I would strike the highlighted language on page 2, starting at line 3, going to line 5.
And that would make you more comfortable and feel like we would have the proper protections in here.
Yeah, I think that would be address the concern that I was raising today.
Thank you.
All right, so other issues? We've been on this one for a bit. If you want to weigh in on anything else in this latest draft, Jared.
And I think I tried to sort of preload some of those smaller quick answers. I knew this was going to take the bulk of the time, so I don't have anything else at this juncture unless there are other questions.
Okay, all right. Any other questions for Jared at this point? All right, not? Yeah,
So I just want to make sure I understand that if somebody is found not restorable, but they're dangerous. I mean, again, I don't think the option is out loose in the community or unsupervised. So I'm wondering, I know like the language in the Maryland statute is basically if they're dangerous at that point, you proceed with a civil commitment. Does Vermont, like, would that work under Vermont law?
We don't really have, we don't really have a lot of the civil commitment structures that either the federal government or other states have. There are many different models for that. And in fact, in prior sessions, I believe we did propose legislation that would have created a more broad application with a process that applied to court-involved people for a broader range of charges, with a whole lot more language to it, basically. But we don't have, for instance, a civil commitment process that applies to the intellectually disabled community. There is only Act 248 that applies only to a court-involved person. All of that was repealed when they repealed the Brandon Training School statute. That's sort of what that was. And because they also peeled away, by they I mean the prior session to the legislature way back when all of that was taken away, they also repealed all the civil commitment language that allowed something to occur that would be sort of parallel but civil to, like, for instance, an Act 248. That's not there anymore.
Is it there for somebody who is dangerous not due to a developmental disability? Or you're saying that got peeled back too?
So for people who have mental illness that can be treated by the Department of Mental Health, there is the ability to ask for involuntary orders of hospitalization, which is sort of what we have called out in this draft to allow that to still happen. There is that civil process for that. We call it an EE order, essentially, when an evaluator says that they need that level of care in any setting, even DOC. I think once the person has been ordered in, that's the existing, what you see now is the order of hospitalization and O&H process is the only civil process that can occur. So if you are not a person that is served by DMH and you are not a person who is served by Dale, there is absolutely nothing. If you are a person who is served by Dale, you can not be compelled into services except through a criminal process. And if you are a person who can be served by DMH, you're familiar with with that process, but that's all that is.
And my earlier question about the person with Alzheimer's, where do you think they're going?
So under the current law right now, there's nothing that applies. Under this law, a court would have to determine what their level of risk is. I think in reality, a person with Alzheimer's, I could foresee them being ordered to a memory care facility.
A secure.
Yeah, I think that there's nothing that if they could be safely maintained in that environment, then a court could order that.
Okay, thank you. Bye.
Yeah, no problem. So we'll go to Matt, and then we'll take a break after Matt. So thank you, Jared.
Thank you all.
Matt, if you could join us and weigh in on the latest here. And, I don't know if you heard us earlier, but we're actually looking at what's called draft 3.1, but it's the same draft that we sent to you. Eric just hadn't changed the number on it. So if you can join us.
I know the way this works. It'd be great to see these things more. Yeah. a short time before I have to talk about it. But it is what it is. I guess I've been seeing it long enough, so, you know, I'll give it my best shot. So, Matt Valerio, I'm the friend again. The redraft is taking steps toward addressing some of the concerns that I brought up in prior testimony. I am happy about the understanding that the Department of Corrections is not the best place to supervise this. Whether the secretary of the agency is the right person, I'm not sure. I don't really understand the Department of Mental Health's reluctance to do something that is so obviously a mental health issue. But, you know, my guess is it's funding and resources. But this is going to take funding and resources one way or another. So as I read through this, I'm just going to kind of go, I have to, I think at this point, start going through this page by page rather than just giving you general ideas as I have in the past, because we're getting down to that point. So I don't really have any issues with page 1. There's going to be a recurring theme, however. You crossed out, and I wish Eric was here so I could ask him what he was trying to do. Where throughout the suffers from a qualifying condition has been replaced with the word has.
And I can tell because you weren't here when he mentioned that, because it's consistent with for persons in need of treatment, where the language is has a mental illness that leads to danger.
And the confusion that arises as you go through this is that, particularly when you get to insanity defenses, is it's really like a two-stage analysis where traditionally what we look at, is there a major, you know, from a legal standpoint, is there a major mental illness? That's your condition, right? And then does that condition, like even in incompetence, render you unable to understand the proceedings that are around you in the most general terms? Or if it's insanity, rendered you unable to control your behavior and conform with the law on if it's an insanity defense. In reading it as it go through this, it's less of a concern in the competence side of things and more of a concern in the insanity side of it, and then even more of a concern when it comes to developmental disabilities or traumatic brain injury or other organic brain problems, because there is no major mental illness. It will never go away. You will never be competent or to do what you do. So like the two-stage analysis sort of fails. All right. And so to me, it's a drafting issue. I know what you're trying to do. And so, and I guess I understand from what if he's saying I'm trying to mirror other statute, I guess that, you know, that's one explanation. I just don't know if it's the best way to do it. And it's a wordsmithing thing. It's not as much of a complaint about what you're trying to get at. It's, you know, when you're, you know, if you're a lawyer and you're arguing this stuff in court, you want to have it be as clear as possible for all of these three types of sort of categories of affliction that you're going to deal with. And so I bring that up, and I will bring it up again as we go through this. Page 2, you change, you add the Commissioner of Aging and Disability. And I'm going to have something to say about that process. And as well, I appreciate the recognition of this other group of people that Jared was talking about earlier. But the problem is not in kind of what you did. It's what Vermont doesn't have. You know, he's right about the fact that the Act 248 process is not designed to do this. And that we don't have a formal civil commitment process with the appropriate protections to address the not guilty by reason of insanity or the so-called bail group or people in that category. And so it's really a broader issue. I know that first of all, the intent of what you're trying to do, I think is the right thing to do, is recognize that category is different. I think it requires a lot more drafting to create that process than to just say, well, we'll just treat them all like the mentally ill folks. And because they are profoundly different. And, you know, I'm not going to, you know, I know you've had victims folks come in and talk about their terrible situations that they've had to suffer through, and I understand that. And, you know, I'm not sure that it's the law that was the biggest issue there, but let's make sure, if we can, that we have something comprehensive to address the folks like what Jared was talking about earlier. So first, the recognition is good. Second, we have to be much more detailed in creating a civil commitment process for those folks with the appropriate protections that are distinctly different from those who I believe would be appropriate for a forensic facility. Lumping them into one might save some money, but I don't think that's, well, I don't think it's fair or right, and it's not what most states do when you're dealing with either on the federal level or other states deal with it when they're dealing with civil commitment. I don't have any problems with, you know, what you did in page, line 12 on page 2. Made a note here on the bottom. If the court finds after hearing that the person is competent to stand trial, the court shall order the person returned to the custodial status that was in place before the person was remanded basically to the forensic facility, as I understand it. The practical matter, and I've seen this time and time again, is you have individuals who are incompetent. Period of time goes by, they get treatment, they become competent, they're then put back in a correctional facility only to become incompetent again. And because competency is not a static thing, it waxes and wanes, it changes constantly. I think there needs to be a finding before you return somebody to a jail facility that would not cause a decompensation relative to their competency. Like a judge would have to take a look at that.
Okay.
Yeah, go ahead. Okay.
How do you propose to do that? Where they're competent to go and they get released back and then.
Well, they're not
they
released.
relapse, and then,
Being put back in jail.
yeah, how would we go in and protect that from happening?
Well, you'd maintain them in the hospital setting. So that
For how long? Or so I hear what you're saying, and I'm trying to, like, how long does that go on if they're found to be competent, right? And I assume what you're saying is that setting with probably the medication, if I dare use that word, right? That's where they should be probably the whole time, I think, is what you're saying. I sure don't want to put words in your mouth, but But if they go in the other setting and then they relapse, we've accomplished nothing. Matter of fact, we've gone downhill.
Right, that's what I'm saying. And I've seen this.
So how do we protect them?
Well, you keep them in the facility to maintain their competence.
Until they have a trial or they have.
Right, and then once they end up if they end up, whatever happens at trial, happens at trial. If they end up being convicted, then the mental health issues have to be addressed on the other side. But I've seen this over, tell you a story. I had a case. It's well documented, State versus Ronald Bean. Read all about it if you like to. But the bottom line is the guy, I tried the case for 10 days and the guy every doctor looked at him and said, this guy has is flirtily psychotic, but he knows who you are. He knows who the judge is. He knows what he's being charged with, notwithstanding his hallucinations that are going on in the courtroom during the trial. So they're like, he's competent, but he's crazy. So we went through the trial. He ends up being convicted. An appeal goes up in the trial. The case ends up getting reversed by the Supreme Court. It gets sent back down. By the time it gets sent back down, his situation is like decompensated terribly because he's been held in jail the whole time. I mean, it's a terrible story. And this is when he was charged with kidnapping, aggravated domestic assault against his mother, like some real crazy stuff that I'm not going to give you the details of. Bottom line is when he got back, now we start over again with a trial, and lo and behold, now he's found incompetent. And we end up going through the whole hospitalization proceedings, and he ends up in the mental health system. He's been in the mental health system ever since. And various things happen along the way where he's doing well, then he's not doing well, because that's the way these things go. And, if this was something where he's getting consistent care one way or the other, either in a hospital setting or not, or whatever the doctors say you should be getting, that case, I started representing that guy in 1995, and I finished the case as Defender General. I mean, it was like 9 years later. So how long? I don't know. Your guess is as good as mine. It could be these things, when you're dealing with folks with mental illness, these things can be indefinite. You don't know. What I wouldn't want to see happen is this, now they're competent. Now we send them back to a highly stressful environment where treatment is not the main concern. And we start this cycle again, just like you suggested.
And they're a threat to themselves and society.
Well, not when they're in the jail, but
No, but if they're released after they're found competent, and let's say found not guilty, or
if they're found not guilty, then they're found not guilty.
I understand that, but they still have the underlying circumstances, whatever.
The interesting thing is some of these cases, there's an understanding that they don't want you. An insanity defense is an elected thing. The defendant a competent defendant has to agree for you to use an insanity defense at trial. The lawyer can't make that decision on their own. Okay.
Who does?
A defendant, the client, has to first be found competent, even if you have an insanity defense. And then the client has to consent to the lawyer using an insanity defense at trial. Okay.
Does that make any sense?
Well, I didn't think so, because that's what the whole Bean case was about. That I argued with, I did an insanity defense during the thing. My client would just talk total gibberish to me constantly. Never, and I'm like, I'm doing an insanity defense. It's the only thing that makes any sense here.
But he had to agree to it, right?
Well, before that, it was unclear. Bean case is the seminal case on the issue.
Okay.
So it was unclear at that time. The Supreme Court in the Bean case found that if the client is found to be competent to stand trial, then the client can say, I don't want you doing an insanity defense. Right? And, or could consent to having it. So bottom line, you need competent client consent to do an insanity defense. And he never gave that to me. So the Supreme Court basically said that Judge McCaffrey was the trial judge and the defense lawyer. They did it wrong. You have, if the client's found competent, he can tell you not to use an insanity defense.
But he can only, maybe he's competent for 5 minutes.
Well,
He gives you that permission. And then-
believe me, we were doing competency screenings every single day during the trial. Like, they bring in people at lunchtime and check them out. And they say, oh, well, he's definitely, seeing things, hearing things, whatever, but he knows who you are and he knows who the judge is and he knows that he's being charged with this stuff. So to be competent, it's a very low bar. It is not hard to be found competent to stand trial. I've used this before, but it's a quote from the Colin Ferguson case from New York, where he had standby counsel, and he basically said the test to know whether you're competent or not is whether you can distinguish between an orange and a Volkswagen bus. Bottom line is you just have to know who the players are, what you're charged with, and the role of the judge and jury, and in general, be able to participate in your defense. So you saw this most recently in a case the case in Burlington, where the individual who was sentenced 2 days ago refused to allow counsel to pursue an insanity defense when, there were all kinds of issues where maybe you should have, in any event. We get back to really the issue is, do you want to, as soon as they're found competent, do you want to just put them back in jail so we can start the process over again? To me, there should be some evaluation of that decision, as opposed to just, you're found competent and now you go back.
And I guess on that topic, I get that point of somebody could deteriorate if they go back, but also it's a possibility they don't deteriorate and then you're keeping them in this facility that they don't need to be in. And so you
That's
think
why
the judge is the person to make that decision.
Well, the judge is the person to make the decision ultimately, but they're going to be informed by expert testimony, just like they are on all of this stuff. So the clinical director, or whoever the psychiatrist or psychologist is who is testifying on behalf of the facility, is going to come in and say, this is what we think should happen, is to maintain competency in the best interest of this client. It's to keep them in the facility, or no, this one's fine to go back to a correctional facility.
So there would be, you're suggesting that there needs to be other language there that it's what's in the best interest of or something.
Yeah, I mean, I think I wrote something that I can barely read. Yeah, I mean, taking into account the likelihood of the person's ability to be, or likelihood of decompensating in a correctional facility, something like that. I mean, it'd have to be wordsmith, but like I said, I didn't have time to rewrite it. I had time to identify the issue.
Yeah, well, appreciate it.
I don't have anything really to talk about on page 3. On page 4, and maybe I missed it. It doesn't seem like the person has the ability to show a material change in circumstances regarding their qualifying conditions supported by competent expert testimony that would allow them to show they're relying on the state it doesn't seem, there seems to be like there's a part missing here where the person being held doesn't have the opportunity to request that, you know, they can get their own evaluation. Their evaluator will say, hey, this person's condition is materially changed, and that they are no longer a threat of substantial risk of bodily injury to another person. It is only that.
This is at the bottom of page 4.
It's not in here, so I put a little star and said, within this section, which starts on page 3A, if the person competency cannot be restored, the court can hold a hearing within 60 days, blah, 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 and then you order all the evaluations, and then under B1, if continued commitment is ordered pursuant to the subdivision, says it shall be reviewed by the court not less than the shorter of either 12 months, which, by the way, I think you were bringing this up, that's a long time for these, for review of these commitments. Most of them are like 4 months. Some of them are 30 days. 12 months is extraordinarily long. And there's some federal law out there that suggests that that is a due process violation in and of itself. But under this section B1, I think there needs to be a provision so that the individual, who counsel obviously, can produce expert testimony, and you kind of provide them with the key to the facility as well, not just, is the state's evaluator going to say they're fine? They should be able to be evaluated and say they're doing fine. And then you have a hearing on whether or not the judge agrees. On page 5 of 23, this is where I start making these connections between the no longer has a qualifying condition. And I see what's going on where it says that that upon a person's release would create a substantial risk of bodily injury. It can be a little confusing because you can still have the condition, but the condition no longer creates a substantial risk of bodily injury to another person. Many of these people are going to be mentally ill forever, but they might not be a threat forever. It's just, as I kept reading through it, I kept getting stuck on, because your schizophrenia may not go away. That having been said, I know what he's trying to do. I just think I would write it different. I might just do it as a 2-stage process.
What would be the 2 stages? Because
that the clinical director is either no longer has a qualifying condition or is no longer suffering from a condition that, I would do both so that it can be, for example, somebody might have something that does go away. I mean, there's 2 parts. So I'm just reading this.
Yeah, so something like would no longer, services director, that the person, clinical services finds this person no longer has a qualifying condition that would, create, or as a qualifying condition, or still has a qualifying condition, but upon the person's release, that condition would not create a substantial risk.
Right. It's more of a problem, honestly, in the insanity side of the not guilty by reason of insanity than it is on the competence side. Because you can have a psychotic break for whatever reason. You can have something that occurs. I was my stepfather had a virus that attacked his liver. And all these toxins would go into his brain, and he would be nuts. I mean, he would just, they didn't really know what was going on until they discovered, oh, your liver is failing. And once then he ended up with a liver transplant. But ultimately, the bottom line was it wasn't a mental illness that was causing it. It was a condition that was medically treated. And once it went away. But he would do crazy things when all these toxins that were, invading his body were coming out of his liver. It wasn't a brain dysfunction. It was an other organ dysfunction. It's just any kind of reason why you might be insane at the time of a particular event. And I can see this in certain types of motor vehicle offenses with death resulting, where you end up charged with second-degree murder or something like that. Reckless disregard, or that kind of thing, that you might cause death, serious bodily injury. So I'm just I see that as being it's different in the insanity side of things. Anyway, I would just, it's almost like if this is your bill, but I would want to run it by Eric. Say, is there a way to just clarify this to identify the two different things that we're looking at? Again, all right, I didn't have any other real issues on this page. I always find, and this is the part where if you work in this business long enough, you realize bad things happen. And it's unfortunate, more than unfortunate, it's tragic sometimes. But the review every 12 months of somebody who's been released, it makes sense. But really what we're trying to do here is predict that clear and convincing evidence that supervision is necessary to prevent the person from becoming. Good luck with that. That's all that's a tough one. And I don't know if those reviews might be better also more than once every 12 months. And this is what I've talked about before, where we don't affirmatively and consistently look at people who are released with either medical conditions that they deal with medicine, or it could be anything from housing, counseling, home, dealing with transients, all of the things that might lead to deterioration mentally. I think we have to look at it. To me, we have to look at it more than once a year. And I do think that having, again, people akin to probation officers, but looking at it from a social work, mental health standpoint, try to make sure that people are taking their medication, that they aren't homeless, that they aren't putting themselves in jeopardy of decompensating and causing problems in the community. That's a place where we should also be more consistent in how we look at these things, or how often we look at these things. I don't really have much to say about page 7. That the is suffering part is still one of those things that I've just marked it. If I was in court, I'd just say, Judge, you just note my objection, and so I don't have to keep making it.
Objections, no.
Okay. Section 2. Not totally sure what to make of this, the added part. there might be, I don't know what to do with this. I know when Senator, she put this in, it was, I know what he was trying to get at, so that these misdemeanors don't just linger in court forever, and that makes sense. But now we're adding others. It makes some sense, but it also you know, what ends up happening is they're dismissed without prejudice. So if they have to be brought back, they could be anyway. So, you know, where we're going to have hearings on whether we should dismiss cases without prejudice. I don't know. I just put a big question mark. That was what I put on the sheet. Because do we really want to spend time with this, or do we even want to talk about it at all? I don't know. I mean, honestly, I would ask a state's attorney, aside from the fact that, you know, the victim of the unlawful mischief or the simple assault or disorderly conduct or whatever that is the misdemeanor might really want to have the case still hanging out there. But what you don't want to see is cases hanging out there with people on conditions of release who haven't been found competent, and there's no real monitoring going on. The only people who are doing the monitoring are law enforcement in the community, who are coming upon people who have been found incompetent a week ago, and their case is still pending, so they just keep filing conditions of release violations to bring them into court to find that they're incompetent again. So, you know, to me, there has to be, you have to address that issue. I just don't know that this does it. I guess I'd have to, my big question is I'd have to probably think about this some more. I don't know exactly how we do it. Would a state's attorney have any idea?
I think my only thought was when I initially looked at the section 2 language, I was sort of understanding it not to have any hearing at all, that it was just going to be a judicial sort of, you know, they look at their inactive status cases, and when it hits a mark where
Well, you know, the thing is with the misdemeanors, it says when it reaches a time equal to or greater than the maximum sentence, 2 years.
yeah,
We're going to sit with a misdemeanor for 2 years on the books. I mean, that's the part you know, I get that. But it's 2 years. It's just, I don't know.
yeah.
Yeah. We need,
I don't know exactly what to do with that.
well, so you're mainly talking about the victim notice or the victim.
Victims should be notified of anything that happens with the case.
Yeah, they should be notified, but it's whether there's a hearing or not.
Yeah, or what's the nature of the hearing? Like what is decided? You know, you have someone on conditions of release for 2 years already. I honestly believe that it's a little off topic, but to me, if you've been charged with a misdemeanor and you've been on conditions of release for 2 years and the case hasn't been brought to trial, you should be dismissed anyway, because you've basically been on probation for 2 years and you haven't violated. So, but that's you know.
We'll take that one up next year.
I hear this a lot. It makes too much sense to do immediately, but you know, in any event, the not guilty by reason of insanity people. This is again that issue, the suffering from it. It's more important. That issue is much more important in this than it is in the competence part, I think, because you're not saying that the person's incompetent to stand trial. If anybody ever was actually found not guilty by reason of insanity at a trial, they've already been determined to be competent. But this is, I think this is only for murders. Right?
Life sentence.
Life sentence cases. I would just want to clean up that language.
You're still concerned about the suffering.
Yeah.
But that's the same
issue, but it actually becomes more relevant in insanity cases than it does in competency cases. Where this would probably arise more is where we have both the state and defense agree, and the experts agree that the person is insane at the time. Like I said, nobody in the collective memory of the defense bar that goes back over 50 years can identify any case where somebody was found not guilty by reason of insanity by a jury. They're not really good cases to take to jury, apparently.
You know how many have been tried?
Well, yeah, I mean, I don't know total, but I know that they are, you know, you might get one or two a year.
Yeah.
And even as defense lawyer, really, you're going to do, if you have absolutely nothing else, you're going to probably have to do that. But the defense lawyer knows that that's not the way to, quote unquote, win a case. It's not a way to get an acquittal, because it doesn't happen with jury. You know, I refer back to that Bean case. The guy was literally pointing at things in the courtroom that weren't there and talking to them during the trial. And yeah, you know, this was the story I told you about the guy on the street later who said, we're never, you know, yeah, that guy was crazy. We're never letting him out. Yeah, exactly. I get it. But you know, it's not really, honestly, it's not really a viable defense for juries, but there are times when everybody can just agree because all of the experts agree that the person was insane at the time. I find it on page 14. I don't really see anything else except for the suffering part on page 13.
Right.
Right at the top, if the state's attorney establishes by clear and convincing evidence that the person is no longer suffering, would the state's attorney ever be trying to do that? Isn't it more like if the state's attorney fails to establish?
Yeah. Yep, thanks. Yep. Thank you.
I was trying to explain this in the Senate, this exact same language, and ended up getting in an argument with Morris. Like, state's attorney, like the state's attorney would never be doing that. So it'd be either the person establishes or the state's attorney fails to establish.
Yeah, no, it fails. Yeah, right.
And again, it's that I think in this one,
We have that language somewhere else.
Yeah.
Yeah.
Correct.
Right.
Yeah.
And all right, I'm skipping to page 16 because the other stuff I've already kind of talked about. I immediately got on to sub B, lines 4 through 6. Competency, like defining competency can be restored. That's just like all wrong. I mean, I know what you're trying to do, but you should have some very specific guidelines that maybe even would have an exception. So what is it? 4 months, 6 months, 10 months, a year, whatever it is, whatever foreseeable future means, because I don't know what that means. And I know what 4 different, like federal circuit courts have 4 different standards of how long you get to work to do that. Some are as low as 30 days. Some will go 4 months. Some say 6 months. Some say a year. But and this part about, I would like to see something more defined there. The other thing that I would look at is capacity to permit the proceedings to go forward. We actually have definition of what competency is in case law that's pretty explicit. And you should put in that what that case law says, which is that you understand, who the players are, who your lawyer is, that you are in court, that you have these charges, you understand what they are, the role of the jury, and the capacity to participate in your own defense. So capacity to permit the proceedings to go forward is not really something in law that anybody understands.
Angela.
I appreciate that. And a question about this, or question that this raises for me, and I was thinking about it earlier as well, like on the issue of competency restoration timelines, trying to predict how long a person will remain competent and the best environment in which to hold them so that you can try to increase the chances that they'll remain competent for the longest amount of time. It occurs to me that missing from that conversation is the larger context, which is the courts system, like how cases get placed on the schedule. And is there currently any system or practice of like prioritizing when someone's achieved competency, then it's like, all right, let's get their case in.
That isn't really how it's done, but anybody who's held does have priority. And that's really the way it's done. So like the older the case, if you're being held, the quicker you're going to get in for a trial. You also have the so-called 60-day cases, which many of the serious cases would qualify for. So if you basically demand a trial, once you've then found competent, the state would have to commence trial within 60 days. So there are ways to handle that. The delays really all surround how long does it take for us to get a competency evaluation. And then we have a hearing, like all of the process around competency is what takes the time. And once they're competent, if they're being held, and if somebody demands a trial, you can get a trial. You can get to trial.
Okay.
And honestly, while all that other stuff is going on, you have, I mean, I know defense lawyers, if competency is really a serious issue, and most of the time, like if you're asking for it, it's at least more than plausible. You've got a lot of time in between then and the actual trial. You may not be actually working on the trial part of it because you're working on the competency part of it, but you can have investigators like working the file up. But you do have the 60-day cases that almost all of these would qualify for.
Thank you. That's helpful.
Not the misdemeanors. I get it.
All right.
So
we need to work on that.
Yeah. Yeah, and that's the thing is, I almost look at that as like this is kind of a placeholder for the language that we should use, because the concept is right. You just have to make sure that the elements that you're dealing with are the elements that the law recognizes for someone to be competent, and it also is the time frame for due process has to be more fixed, less squishy.
And I think 18 USC 4241 has that kind of language in it. This just takes part of the language.
Yeah. The other thing is, I mean, Jared used the federal.
Yeah, this is.
But we also have Vermont case law that is pretty clear on it too. So all right. From there. On page 20, line 4, did you mean under rulemaking, did you mean Commissioner of Corrections or did you mean Secretary?
So we didn't change where in the first 3 sections we changed the secretary. We didn't change it in the other sections, which has primarily been this committee, but that's going to be meshed up.
Okay. So that's
What's that?
the intent is to
I believe that seems to be where corrections and institutions is going in the other, is that kind of.
That's kind of what I've been informally told that they're feeling the same.
Right. So we just haven't gotten their changes put into this yet.
Yeah, I mean, honestly, it's, well, I guess I don't have to rehash it. This is not really a corrections issue.
Yeah, don't need to rehash that one.
I have nothing else.
One, yeah, go ahead.
Just on, page, 4, your point about you need to have something in there for, change in circumstance.
Yes.
So I still don't quite understand is like how this will sit with 48.1.4, where you can seek a new evaluation on a change of circumstance for competency competency finding.
Well, isn't this the part where you are held you found incompetent?
Yeah.
And you are
You have
able to be released to the community.
I'm actually before that. I'm on page 4, bottom of page 4. So continued commitment.
Right, but commitment to me is not necessarily, you can be committed, I guess, to the custody of the Secretary of the Agency of Human Services, but not held in the facility. Is that?
Oh, it's in.
Yeah, it's somewhere there's the least restrictive language.
Yeah, it's right there, right at the line 15, 16.
Right, there it is, yeah.
Now, my office wouldn't be doing this because if they're already found incompetent, now it's in legal aid's hands.
Yeah.
We used to do it, but I could see an individual saying, hey, I don't need all these conditions anymore, or I am being held but things have changed and I have an evaluation from my doctor who says, so now we have an argument.
Yeah. Okay. And they couldn't just use. I understand.
Because otherwise, all basically the key is totally in the hands of the state's attorney.
Yeah.
Not the person doesn't seem to have a venue or a procedure to do the same thing.
Yeah. No, that I just needed that. Okay. Thank you.
Okay.
All right. Okay, good. Thanks.
Thank you very much.
Thanks, Matt.
You got all that?
We took a break.
I'm like, yeah.
Howard, we're welcome to take a break, but I think.
There was a time some number of years ago when literally every time I sit down,
We'll lose the.
2 people who were on the committee. Every time, no matter what it was.
Need 5 minutes or?
Break as you need.
I had a hard stop.
We need a break.
You just had a break.
All right, so let's hear from Commissioner Bowen first, and then we need a break after that.
You can stand up and breathe or something.
Yeah, sure.
You can open the window.
We should open the window, it's so hot.
Well, I come back in.
Okay, if you could comment on the latest. Right?
The one that I saw late last night.
Yeah.
Okay.
Yeah.
So I don't know that.
There could be more time, and we're gonna, obviously, we have some suggestions already on language we're gonna be working on. So if it's a little premature, we can, if you have anything to say right now, but we'll have you back, certainly.
Yeah, so I think that we're digesting it as an agency.
Right.
I thought that there was that some of the clarifying points were useful. I think there's one thing I'll just pop for you. I think it was probably just an oversight, but on page 19 at the top, it left off the Commissioner of Dale. It's everywhere else, but it's just in that one spot, and I think that could end up being important.
So can I just, I guess, ask you a question then in advance of you having had a chance to look at it a little bit closer? We had a lot of discussion this morning on page 2 of lines 3 to 5 of the inclusion of the individual, that if somebody is subject to an order of commitment under Act 245, that 48, sorry, that they wouldn't be sent to the forensic facility. It got some significant pushback from state's attorneys on that particular issue because it's not same level of security necessarily for these high-risk individuals. So if you could just comment on that.
Yeah, I mean, I think that that's what Act 248 does do. So it's sort of like a parallel to that. So I think that there are different opinions about that. I think that that was testified to in Human Services by Jay. So I think they need time to come together, maybe. So it's probably premature. I don't have a concern. Like either way, it can work, you know. But that was what was brought out as an understanding that the folks who are like who meet criteria for Act 248 would come into Act 248. Again, that's a small, very small percentage of the people I think we're talking about, because that's only for people with intellectual disabilities, not the whole range of people with developmental disabilities. Those are two different things, right?
It's somebody who has had the condition before they were 18 as well, my understanding.
Right. Also, there was a focus on who is currently in corrections currently, and who, if they were eligible for Act 248, they'd probably be in Act 248 right now. So there's an understanding that we're focusing on a population that is currently incarcerated, but not, there's not really anything happening in terms of restoration, assessment of restorability, or risk assessment. So that population is the focus. But I saw that you added that. I'm sure there will be quite a bit of discussion on that, but it was just testified to in that way by the administration. So we'll see.
Okay, all right.
We shall see. Then the question about conditions that I heard. No, he's gone. So just when I first looked at it, I had the same kind of question about, you know, are we talking about clinical condition or is that a legal understanding? If it's a legal understanding, then I think it just needs a definition, because for sure, people with developmental disabilities, people with chronic mental health challenges are not going to suddenly not have those. But if it's a legal definition of what constitutes a qualifying condition, it's just by virtue of having a diagnosis, you do not have a qualifying condition. You have to have, right, legally speaking, you have to have committed or be charged with a crime. You have to be not competent, all of those things. And if there's a driver behind that, that is one of the many challenges that somebody might have that would lead to perhaps a contributor to getting, you know, being in that legal situation. So if that was what was intended, because that's how it was explained to me when I asked, then that made sense to me. If in fact you are defining it as a clinical condition, then you have to shift that a little bit, because that should not be the reason why somebody is in the situation that they're in, or that qualifies for the situation, right? That makes sense?
It did. I mean, the definition was specifically related to whether, for whatever reason, they were found incompetent to stay in trial.
Yeah.
Or not guilty by reason of insanity.
Right. So maybe it's just in the definitions to be clear about that. If people are saying or misunderstanding it, if that's the case, or if in fact it does indicate that the person has one of the diagnoses. But again, that's mixing clinical and legal, when competence is a legal question, you know, legal decision, and clinical helps you. Clinical is the process that helps you restore competence, it's the process that helps provide, risk mitigation. That's where the clinical pieces come in, the evaluations for competence. So just that we don't mix them.
Okay. Don't understand that. So we'll probably give you some more time.
Okay.
Yeah, and.
As a group.
And perhaps we'll, try to address some of the, issues that were brought up, in other testimony that we've had and have that with enough time to look at it before.
Yeah. It's important that the one place on page 19 where you didn't have that, it's just important, not just for the people with developmental disabilities, but also that it's not understood as always just mental illness, because that is just a very common misconception. Yeah.
So I was asking about the person with Alzheimer's.
Yes.
Where would they go, or do we also need to add the commissioner's health?
Well, it's probably a good idea to add the Commissioner of Health because of substance use.
Right.
As far as Alzheimer's, that would probably come under Dale because we're a division of disabilities, aging and independent living, but there isn't a clear process right now. Right. So, but the aging piece of it, but if you're contemplating health department, that's where the substance use services, that's under the health commissioner's portfolio. So you might consider that. They don't, right now, the health department does not have committed to the commissioner. They don't have a place for that. But it is something to think about. With substance use, that's another issue because many people, when there is a place where people with substance use chronic substance use or impact of the substance use on the brain, et cetera, could be considered not competent. But many times, once the intoxication resolves, they're competent.
And they contract with people that provide residential treatment.
Yeah.
So they should.
Right. So it's something to consider whether you would want to have them be a consultant to in a situation which you've laid out here. I do want to say how much I appreciate the thoughtfulness that has gone into this bill, the multiple iterations, which in many cases it's that. But I definitely don't want to stand between you and your parade.
Appreciate. Any other questions at this point? We will take 10 minutes and then we'll,
Thank you.
20 minutes with, Jack, and if we need Jack back,